First legal lesson of the day. Before justice can be served, earbuds must be conquered. And right now, justice is losing.
Hey, Valerie, for some reason I'm even the earbuds are not working.
Can you switch over or just give me the computer? Right? Right?
Don't get any sound. This and
Okay. Move up to maximum. And let's do this first.
okay.
See if we're not.
I'm gonna go upstairs and get another pair of earbuds.
Yeah, that's a good idea. Participants, chat, raise hand, share, companion, keys. Hold on. I know this pair works, so thought I'd check it out first. Oh,
Goes out.
I know.
I mean, when my sound goes out.
I know which one. Yeah, I'm still not getting that either. All right, here. You want to log in on my computer?
Yeah.
Hmm. It's definitely going on. Nope.
How do I get to how do I get to
Oh, here.
Zoom?
Come on, sweetheart.
No, it's not sign in.
I need to sign in, huh?
Oh, all right. You want the password? Oh, you want to hit join.
Uh-huh. Just let it go through its little steps.
Okay.
There we go.
Code.
I'm gonna log you out of this.
Yeah. 0701141. Okay, join. It's Valerie Mills comes up.
It's okay, you can tell them who you are. Well, here, I can do it here. Okay, Attorney Andy Fanta will be logging out and then rejoining as his wife, Valerie Mills.
Switching laptops.
Hmm. You want earbud
No, because your computer has
sound?
sound.
Yes, it does. All right.
Courtroom rule number 27. If the audio fails, the stress level rises by 200%. Valerie is trying to hold this ship together.
Well, look at you, how handsome.
Thank you.
You're welcome.
Makes my day.
All right, well,
And Andrew's in.
good.
I just want to get it adjourned to the 4th of September.
Like a little,
It's getting thin on top, though, isn't it?
yeah, it's getting a little, but okay. Hey, sweetheart, you
What?
gotta add a hair. Most people your age don't.
What happened to your A here?
What age? This is, look here.
Yeah.
Here, this is just from me using it. I wrote 2 books on this.
Oh, okay.
Kind of my version of the dining room table in Canada.
Oh. Well, thank you for getting me set up. I don't know what happened to my computer. A glitch, I guess.
You just go out to Bartwood to the Apple store and say, here.
Well, it fades in and out.
It doesn't matter. Here. Like, I won't be here. I'm taking that mine with me. Just saying.
Okay. Yeah.
Fun fact, judges and lawyers, still human, still dealing with Bluetooth mood swings, Wi-Fi betrayal, and mystery device settings.
I
All right. Once again, District Court for County of Washington, State of Michigan, now back in session, the Honorable Judge J.
You may be seated. Court does call the case of People versus Anitra Comer or Coomer.
Andrew Childers appearing on behalf of the people.
I'm sorry. Apple. Anybody know where Miss Apple is?
Here, I can cover.
Okay.
Your Honor, Alexis Pluma appearing with and on behalf of Ms. Coomer, who I believe is going to be entering into a plea agreement today.
Yes. Miss Coomer, can you unmute and state your name? Can we get her unmuted? All right.
Assistant Public Defender Hannah Apple on behalf of Ms. Coomer, Judge.
We're just trying to get her unmuted here. We're trying to force it.
Yes, sir. There you go.
Okay. Ms. Coomer, can you state your name, please?
Anitra Coomer.
Thank you. I have before me a plea form that indicates that the defendant would be pleading guilty to the charge of assault and/or assault and battery, 93-day offense. Upon her successful plea to that charge, count 1 would be dismissed. That is the court's entire understanding of the agreement.
That is correct, Judge, and I did have a chance to review that as well as the advice of rights form with my client, and she did give me permission to sign both of those on her behalf.
All right, very good. All right, ma'am, could you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name again, please.
Anitra Lynn Coomer.
All right, Ms. Coomer, it is this court's understanding that you are going to be pleading guilty to the charge of assault and/or assault and battery. That's a misdemeanor punishable by up to 93 days in jail, $500 fine plus court costs. Do you understand that?
I do.
And understanding that, do you still wish to plead guilty?
I do.
And to that charge, how do you plead?
I plead guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Correct.
Ms. Apple went through an advice of rights form with you. Is that correct?
She did.
And you understand that all of those rights she went through are rights that you'll be waiving as a result of this plea.
Correct.
Did you have any question regarding any of those rights?
No, sir.
You understand you're giving up your right to appeal of right.
Correct.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No, sir.
Anybody threaten you or coerce you?
No, sir.
You're doing this voluntarily?
I am.
Of your own free will?
I am.
And also because you believe that you're guilty of this offense?
I do.
August 5th, 2024, at the location of the Huron Valley Correctional Facility in Pittsfield Township, Washtenaw County, state of Michigan. What did you do involving a Bridget Gifford that makes you think that you're guilty of this offense?
Your Honor, may I have one, dear?
Yes.
Thank you. Ms. Coomer, on that date and time that the judge stated, did you make contact with Ms. Gifford?
I did.
Okay, and you, by pulling her hair?
I did.
Okay, and you did not have permission to do that?
I did not. No.
And that act upon her was not in self-defense?
Correct.
Defense is satisfied.
All right. And ma'am, you understand that if you commit misconduct as defined by the Michigan court rules between the time I accept your plea and the date of your sentencing, that any agreement, although there isn't any regarding sentencing or any evaluation of your case, the court would not be bound by, and also that you could not use that as a basis to withdraw your plea, or would not be permitted to withdraw your plea. You understand that?
Yes, sir. Yes, sir.
Counsel, are there any other promises, threats, or other inducements which you believe or you know of that have led to this plea?
No, Judge.
All right. Have I complied with the court rule? Would it be proper to accept this defendant's plea?
You are satisfied.
Defense is satisfied.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Normally, I can't do it on this case because it's victim's rights case. So a pre-sentence investigation and report is ordered. Sentencing in this matter will be
August 13th at 9 a.m.
can't do August 13th because I need 2 weeks for a video writ. It's going to be the
August 27th at noon.
August 27th, 2025, 12 noon. And that's before me. Bond will continue. All
Thank you,
right.
Judge.
All right. Thank you, ma'am.
Thank you. Thank you.
Court does call the case of the people versus Jennifer Lindsay.
Sorry, Lori Jackie, Assistant Public Defender with and on behalf of Ms. Lindsay. Ms. Lindsay, can you state your name for the court?
Jennifer K. Lindsay.
You're requesting an adjournment.
Yes, Your Honor, for some additional discovery.
Probable cause conference without objection, August 19th, 2025, 9 a.m.
Thank you.
Bond will continue. Thank you, Ms. Lindsay.
Thank you. Thank you.
Court calls case People versus Justin Duffany.
Victoria Burton Harris, Assistant Prosecutor on behalf of the people.
Kyle Burrell on behalf of Mr. Duffany, who's approaching the podium as we speak. Mr. Duffany, please introduce yourself to the court.
Justin Duffany.
Thank you, Judge. Today's the date and time set for probable cause conference. I was just appointed on this matter yesterday afternoon, so we are asking for a brief adjournment for discovery and for plea negotiations. At this time, there's also a bond violation, or a—
There is.
Yes, Judge. So I spoke to Mr. Duffany. He went to community corrections yesterday at 4:20 p.m., but he did not have the money to test, so he was unable to. We did discuss today. He's going to go immediately to community corrections after this. I do have an email from community corrections to confirm that he was there.
Is he going to test clean?
I believe so, Judge. Yes. He's on what?
Are you going to test clean?
I'm on Suboxone. Yeah. I'm prescribed Suboxone.
You're prescribed it? I'll pass it. He needs to get over there and test and then come back.
So thank you, Judge.
I'm not doing it anymore. Takes too long. Just go on. Court calls the case People versus Jonathan Faith.
Good afternoon, Your Honor. Bovis with and on behalf of Mr. Faith, Jonathan Faith, introduce yourself to the court.
Mr. Faith, can you state your name, please?
You gotta unmute.
Jonathan Faith.
Judge, this is first PCC. I just got the discovery. I subbed in this week. I'm asking for a brief adjournment as well.
As soon as the prosecutor puts her appearance on, we'll be happy to proceed.
I was trying to wait.
I know. You were going to start, but he just kept talking. Go ahead.
Sorry, Judge.
Victoria Burton Harris, Chief Assistant Prosecutor, again appearing on behalf of the people.
Do you have any objection to the adjournment?
I do not, Your Honor.
Probable cause conference in this matter will be adjourned August 19, 2025, 9 a.m. Bond continue.
Thank you, Judge. Good seeing you.
Thank you.
Bye.
Court calls case People versus Andrew Gendy.
Good afternoon, Your Honor. Andrew Fanta on behalf of and with Mr. Gendy.
Jennifer Douglas for the people.
Good afternoon, Mr. Fanta. Long time no see. Hope you're doing well, sir.
Thank you, Judge, and you as well. And Your Honor, I just received discovery, and I would like to get this matter adjourned. Would that be on a Tuesday or a Thursday, Judge?
Well, this month we have both. I have Tuesday the 19th. It would normally be adjourned to a Thursday. So I have the 14th, the 19th, or the 28th.
I can't do, could we adjourn it to September, Thursday, September 4th?
Wow.
I know I'm going to be out of the country, and I'm going to be in northern Canada, and I don't know whether I will have any internet connection.
I hear they cut it off for all Americans. No, I'm kidding. I don't know what happened. Didn't used to happen that way. All right. So wrong. Well, give me this. September 4th. Any objection to the September 4th date? All right. I will do that for you, Mr. Fanta. We'll adjourn this to September 4th, 2025, 9 a.m., or as your invite indicates, bond will continue. Right?
Thank you so much, Your Honor, and
thank you. All right. Safe travels, Chief.
Thank you, sir. Bye-bye.
Bye-bye. Court calls the case of the people versus Naia B.
Good afternoon, Your Honor. Sam Bernstein with and on behalf of Miss Lee. She's coming up. Miss Lee, could you please state your name for the court?
Naya Lee.
Others? All right. Anyway.
Your Honor, we're asking for an adjournment to review discovery. A bit past 2 weeks if possible. We're waiting on some things that might take a while to be produced, so.
Without objection, August 19, 2025, 9 a.m. Bond will continue. Thank you, sir. Court calls case of the people versus Jaquan Holland.
Stephanie Cannon.
No, we'll wait for you to have the conversation. Are you talking about his shorts? Lack of pants?
Yes, Your Honor.
You are?
Yes, I was.
What'd you tell him?
I told him that we have to dress appropriately for court from here on out, not to wear shorts.
Did he understand you?
He understands, Your Honor. He's apologetic. As soon as he leaves here, he's going to work, but he'll make sure he's dressed appropriate next time.
All right, what are we doing in this case?
Your Honor, I'm just asking for a 2-week adjournment on, or actually, you changed your mind. You said you want to go to exam, correct?
Yes.
Your Honor, my apologies. When we spoke yesterday, we were adjourning. Today, we are going to go ahead and set it for a preliminary exam. I'm going about the rules.
That was dramatic.
I'm sorry, Your Honor. Also, Your Honor, can I address Bond when you're ready? I'm sorry.
He's out.
He is.
Oh.
That is accurate, Your Honor.
Okay.
He is untethered, though. We would like to ask for the tether to be removed. This case it happened.
Set the preliminary exam first?
We can. We absolutely can.
Discovery is complete?
Yes, Your Honor.
Would people have their witnesses available to 12? Preliminary examination in person, August 12th, 2025, 9 a.m. That is before Judge Valvo. Yes, Esteban.
Esteban, Your Honor, we'd ask for the tether be removed in this case. This case actually happened over a year ago, more than a year ago. He's had no contact with the complaining witness. He's not going to have contact with the complaining witness. He comes to court. He's in front of Judge Hamoud. He's never missed a court date, so that's not going to be an issue. He is not a threat to her or to the community, Your Honor. We are asking for the tether to be removed.
Response.
Most people that are asked for the tether stay in place. I did do the arraignment on this. We are asking for that tether to stay in place for the safety of the complaining witness. The only restriction that this tether has, based on my notes in his arraignment, is he's not allowed to go to that particular site. So I don't see how that inhibits him in any way.
Your Honor, she doesn't even live in Michigan anymore.
Oh, I don't know that. I mean, I know you're telling me that.
I understand, Your Honor.
I don't. The motion to modify bond at this time is denied. Certainly, you can take it up after preliminary examination with Judge Valvo on the.
Is it Valvo or Fresh Hour, Your Honor?
What did I tell you? You didn't write down what I told you.
I wrote Fresh Shower, but you just said Valvo, so I want to make sure.
Which judge did you give me? Valvo, right? That's what you said, and then I said it.
And Your Honor,
So you said Valvo, I said Valvo, she wrote Fresh Hour.
I'm getting old. It's my hearing. It's going.
So it's Valvo.
Thank you.
All right. Court calls the case, People versus Antoine Coleman.
Good afternoon, Your Honor. Kerma Dadush on behalf of Mr. Coleman. Mr. Coleman, can you unmute and state your name for the record and remove your hat, please? Thank you. You have to unmute first.
Alan, can you get me that last one?
Now I have it.
Yes, we can hear you now. Can you state your name for the record?
Antoine Coleman.
All right. I have before me, hold on a second, a couple. Is it the one that I have before me a plea form that indicates that the defendant will be pleading guilty to an added count 3 of operating while intoxicated, second offense, the 1-year offense. Upon his successful plea to that charge, counts 1 and 2 would be 1 and 2 would be dismissed. That is the court's full understanding of the agreement on this agreement form. I do have in here a memorandum of understanding regarding transfer of jurisdiction. Is part of the plea.
No, it was not contingent on anything else at this point. It was just contingent on the screening and referral process that's done. So it's just as is.
Very good. Is that your understanding?
Yes, Your Honor.
All right. Sir, if you could please raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth so help you God?
I do.
State your name again for the record, please, sir.
Antoine Coleman.
All right, sir, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated, second offense. That is a misdemeanor punishable by up to 1 year incarceration and a $1,000 fine plus court costs. The court could order any community service or rehabilitative services the court deems necessary. The court could also order your vehicle immobilized. Court order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that, sir?
I do.
All right. You also understand, sir, that while I'm taking your plea, I would not be your sentencing judge in this case, and that you would be sentenced before Judge Washington in the 14B District Court.
Yes.
All right. Understanding all of that, you still wish to plead guilty?
Yes.
And to that charge, how do you plead?
I plead guilty, sir.
Now, you understand that by pleading guilty, you will not have a trial of any kind?
Yes.
You signed an advice of rights form, is that correct?
Yes, sir.
Any questions regarding any of those rights?
No, sir.
Please look at paragraph 5 of that form. Those are your rights which are part of a trial. You understand by pleading guilty, you're giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, sir.
Anybody threaten you or coerce you in any way?
No, sir.
You're doing this voluntarily?
Yes, sir.
Of your own free will?
Yes, sir.
And because you believe that you're guilty of this offense?
Yes, sir.
August 24, 2024, at the location of 528 East Clark Road in Ypsilanti Township, Washtenaw County, State of Michigan, were you operating a motor vehicle?
Yes, sir.
Prior to operating that motor vehicle, had you consumed intoxicating liquor?
Yes, sir.
You recall what you had and how much?
I had approximately 3 shots and probably maybe 3 to 4 beers.
All right. Were you stopped by the police or was there an accident?
No, sir. I was sitting at the gas pump.
Okay. And the police arrived?
Yes, sir.
All right. And somebody had called?
Yes, sir.
Are you disputing the right of the police to stop and or detain you in this instance?
No, sir.
All right. Were you ultimately arrested?
Yes, sir.
All right. Were you taken to the police station or the hospital?
The hospital.
All right. Was there a blood draw?
Yes, sir.
And what were your blood test results?
Pretty high, sir. I don't know the exact number.
If counsel is willing to stipulate, Your Honor, have blood results of 0.164.
We stipulate to that, Your Honor.
All right. And so you don't have any reason to dispute those blood test results, do you?
No, sir.
All right. And had you previously been convicted of operating while intoxicated on or about September 7th, 2021 in the Third Circuit Court and/or of operating while intoxicated on or about October 16th, 2017 in the Third Circuit Court, and/or operating while intoxicated on or about August 11th, 2017 in the Third Circuit Court.
Yes, sir.
All right. Sir, you understand that between the time of my taking your plea and the time of sentencing, if you commit misconduct as defined under the Michigan court rules, that any evaluation or sentencing by the judge would no longer apply and the judge would not be bound by that. You understand
Yes,
that?
sir.
Any agreement? Okay. You also understand that you would not be entitled to withdraw your plea.
Yes, sir.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No to the people.
No, Your Honor.
All right. And has the court complied with the court ruling? Would it be proper to accept this defendant's plea?
People are satisfied.
Defense is still satisfied.
Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 14B District Court. Sentencing in this matter will be
September 4th at 10 a.m. with Judge Washington.
September 4th, 2025, 10 a.m. before Judge Washington. Bond will continue. Thank you.
Thank you, Your Honor.
Thank you.
Court calls the case, People versus Monica Collins.
Andrew Banner.
Hello.
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 Assistant Public Defender Natalie Pate with it on behalf of Ms. Collins. Ms. Collins, can you please state your name for the record?
Monica Collins.
Thank you, Your Honor. I'm respectfully requesting an adjournment. The phone number I did have for Ms. Collins was her friend, who I believe did help her get to the Zoom today. However, I am needing to have a conversation directly with my client. I'd ask for an adjournment for that to happen and also request that Ms. Collins call the Public Defender's Office to update with the best phone number if possible.
Probable cause conference without objections adjourned to August 14, 2025, 9 a.m. Bond will continue. Ma'am, do you have the number to the Public Defender's Office?
No, can I actually get it right now?
Yes, I'll be more than happy to give it to you. You got something to write it down with?
I'm gonna write it in my notes. I'm actually on my notes right now.
Pardon?
I'm gonna write it in my notes.
I believe on her phone, Your Honor.
I know, I'm not that old. Thank you. Number is area code 734 222 6970.
6970. Thank you.
You're welcome.
Thank you, Ms. Collins. Thank you, Your Honor.
Thank you. Yeah.
For the record, I'm really bad at technology. I'm probably worse than you.
Oh, I know you're worse than me.
Yeah.
You're in my court. All right. Court calls the case, People versus Christopher Cummings.
Abigail Swanger requesting permission to practice pursuant to MCR 8.120 under the supervision of APAG McKenzie.
I thought we got all that over with this morning. No, I saw you. You came in late. Yes, you did. I saw you walk across right there. I did. And I said, hello. Nice of you to show up. Wow. All right.
She made that with the utmost respect.
Is it? Yeah, she still got that permission to practice hanging in the balance. Permission to practice is granted.
Your Honor, Alexis Pluma appearing with and on behalf of Mr. Cummings. Mr. Cummings, could you just say your full name?
Christopher Cummings.
All right. And I have before me a plea form that indicates that the defendant will be pleading guilty to the charge of assault and/or assault battery. On his successful plea to that charge, count 1 would be dismissed. Defendant also agrees that there will be no deferred sentence agreement. There will be alcohol counseling, sex offender assessment, and probation, no contact with victim, and alcohol assessment. The prosecutor and defendant agreed to a sentence agreement of probation with conditions, no deferred sentence agreement. That's the court's full understanding of the agreement between the parties.
Yes, Your Honor. Sorry.
May I have him sworn?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
State your name.
Christopher Cummings.
All right, sir, it is this court's understanding you're going to plead guilty to the charge of assault and/or assault and battery. That's a misdemeanor punishable by up to 90 days in jail, $500 fine plus court costs. Do you understand that?
Yes.
All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court.
Yes.
All right. Understanding all of that, still wish to plead guilty?
Yes.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, that you will not have a trial of any kind?
Yes.
All right. You signed an advice of rights form. Is that correct?
Yes.
Any question regarding any of those rights?
No.
Please look at paragraph 5. Those are your rights, which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily?
Yes.
Of your own free will?
Yes.
And because you believe that you are indeed guilty of this offense?
Yes.
On the date of January 5th, 2024, at the location of 3344 Grove Road, Ypsilanti Township, Washtenaw County, State of Michigan, what did you do with reference to a Bethany Conde that makes you think that you're guilty of this offense?
Gave somebody a hug. And I guess they didn't want me to. Yes. He said, what did I do?
Well, you
Yeah.
just told that to me.
Yes.
Did you want an additional voir dire? I'm not.
Yeah, so you made physical contact with her.
Yes.
She did not want you to do that,
Yes.
and she did not give you permission to make contact with her prior to making contact with her.
Correct.
All right. Sir, you understand that if I accept your plea between today's date and the time of sentencing, that if you commit misconduct as defined under the Michigan court rules, number one, you could not withdraw your plea, and any sentence agreement or evaluation, the court would no longer be bound by. You understand that?
Yes.
All right. Counsel, are you aware of any other promises, threats, or other inducements which have led to this plea?
No, Your Honor.
All right. Have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Defense is satisfied, Your Honor.
Your Honor, we would just ask that the victim's name be placed on the record.
Pardon?
We would just ask that the victim's name be placed on the record.
Good.
Oh, okay.
I know. Plead guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
September 4th at 10 a.m.
September 4th, 2025, 10 a.m. That is before Judge